Right. In 24 CR 2449, you were J.W. Marshall, present with your attorney, Mr. Burbank, and the state's attorney. Mr. Burbank is your attorney, correct? Yes, sir. Right. He's filed a bunch of motions.
This right here is where it starts going sideways. The defendant is trying to file motions while having a lawyer, which isn't allowed. It's called hybrid representation, and courts don't play with it. Either trust your lawyer or go solo, but not both.
On your behalf. And okay, these things that you're filing, the court doesn't accept that. You have a lawyer. This is what's called hybrid representation, which is disallowed under the law. You've got to either trust your lawyer, you run this by him, then he'll do what needs to be done. But this is not things I'm going to consider because he's the lawyer of record. You have a right to be heard, of course, but you can't have two lawyers unless you pay for them. You and him can't do it at the same time. Yes, sir. He's been assigned. I don't know. Did you hire him?
No, I was.
Okay, you were appointed, and okay, you want to represent yourself. Anytime you want to do that, let me know, and that would be a bad choice. It's always been a bad decision, but some people are insistent, and it never works out well for the defendant. But that's been our experience in this room with 18 and a half years and 600 jury trials. We can figure out what's the right way and what's the wrong way. We've seen it so many times. But this is, when you send this, the court's not going to receive it because you have a lawyer and he's the one responsible for filing the motions and representing you. So you don't want to get into a spot of where, well, if you're going to be doing it, he's gone. See you. He's a wise man and he's a good lawyer. You got to trust. Run it by him. He knows how to do it and what is the best way to represent a defendant. Okay. Yes. All right.
Your Honor, if I may, one of the motions that he did file was for a possible bond reduction. I did file an amended motion that I signed on for. The basis, if I may address the court
yes, sir.
briefly,
Yes,
is
sir.
that prior to the charge of murder being filed against him, he was out on bond. There are other cases in this file that he was taking care of, and he was on bond. He was compliant with all the rules and regulations, showing up to court, abiding by the rules and conditions. When this new offense came, then they, of course, put a new bond, raised the bond on the murder charge.
Okay, here's the tension defense wants a bond reduction from $1 million, claiming the defendant followed rules before. But what do you think? Should past compliance outweigh a current murder charge caught on video?
And he's been in custody since then. He's asking for consideration of possibly reducing the bond down.
Okay, this in summary states the bond is presently at $1 million and you are asking on behalf of the defendant that the bond be reduced to an amount that the court determines is reasonable. I know what the background is on why this was done this way, but does the state have anything to add here?
Yes, Your Honor. The state obviously would object to any kind of bond reduction. The defendant has 4 prior felony convictions, so he is a habitual offender. At least 2 of those are in sequence.
Boom, this is the prosecution's knockout punch. 2 people allegedly gunned down an unarmed man, and it's all on video. That's not just serious, it's damning. When footage speaks, juries listen.
Also, the nature of this crime, it's alleged that both the defendant and Jamal McCain, the co-defendant, gunned down the victim in this case, and it is on video. You can see 2 individuals gunning an unarmed victim down and shooting him multiple times, both of the individuals doing that.
Anything you want to add, sir? You need to go?
No, sir. Counsel.
Okay. All right. A couple of decisions the court's going to make. Number one, this court is going to deny the motion for bond reduction. I've reviewed your criminal history. I have reviewed the circumstances of the offense. Those are the key determiners in determining what a bond is under law. Number one, murder. Yeah, that is the most aggravated and violent crime unless it's multiple murder.
And the judge shuts it down. For felony convictions, one being robbery, the judge walks us through it methodically, but the message is loud and clear. You're not walking out of here.
Number two, you, according to this indictment, have at least 4 prior felony convictions that dating back 24 years. And not the least of which is a conviction of robbery in 2007, which is a violent crime. The others are, it looks like, illegal possessions of controlled substances, which are felonies. So this, if true, constitutes a habitual offender. Your punishment range is no less than 25, no more than life years in prison. And that's as serious as it gets. So this is, number one, a serious felony of murder, a most serious felony. It's the use of a firearm. Somebody is killed. It's a violent crime. You have multiple felony convictions, including another violent crime. And in reviewing the probable cause affidavit, this court finds that $1 million in bond is most reasonable under the circumstances of the case and your rich criminal history. So,
New case, new tone. This one's evading arrest, but look how cleanly the plea process moves when both sides agree. It's like courtroom jazz smooth, precise, no drama.
we're going to set this for trial.
We ask that it be said as soon as possible.
All right, y'all, what do y'all need to do to get ready? Because I'm going to try to accelerate this, please.
Your Honor, won't take much. I think the co-defendant is currently set for October. So
Anything can happen in a case. I
think we'd prefer to go on the co-defendant first in October. I think that's when we're set to go on that one. We got everything ready. Mr. Marshall was arrested after this, after we received some additional information.
Lacey, I need this set right after the co-defendant's case.
Yes, sir.
Okay, we'll get it. Please
Yeah,
note
I've
it.
got
And
the file real quick and then
All
I'll
right.
get them a date.
anything else on this?
No, Your Honor, we'll be excused
Thank you.
for that.
That is all. Yes.
Maybe look at it again if we're not ready.
Yes, sir. And you are Kevin Wayne Turner.
Yes.
In summary, sir, this indictment in 24 CR 1711 states that on or about June 13th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with here, sir? If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. There is no fine. You do well, we can shorten it to 1/3. 3 1/3. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal. Do you understand? How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty? Here, help me out. If you can pass that to him. Did you sign that document, State's Exhibit 1?
Yes, sir.
Did you understand it? Discuss it with Mr. Rennan? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. Hold on, everybody. I can't hear. Everybody, thank you. You were mentally competent to enter your guilty plea. There is enough evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, please, Judge.
Okay. Let me ask you a couple of things. Criminal history on the defendant?
No, sir, I don't
No,
know.
there is. This is an agreement for 10 years. You're asking for less?
Yes, Your Honor, I am.
What state's saying?
I don't have a problem with that, Judge,
What
just
are we
based on
thinking?
the
I would
history.
ask for 3, Judge.
How about 5?
5, the judge.
Because again, once again, it's a third. You can shorten it to a third.
A defensive driving course as part of probation. Sounds light, but listen to the judge. It's about remembering the power and danger of a 4,000-pound vehicle. Smart and symbolic.
And it's got to be longer than a misdemeanor,
I understand.
which is
5.
2 years.
If the court would consider 5, that would be very
Okay.
acceptable to us.
All right. If nothing further, I'm going to find, sir, you have pleaded guilty voluntarily.
Yes.
You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea for State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any findings so long as you follow the terms and conditions of probation, which will be for 5 years in length. The probation officer will go over these with you. These are normal and customary. Essentially, most of these, if not all of them, are conditions I have to follow every day.
Yes.
There is no fine here. There is, though, you're going to be ordered to take and pass defensive driving course as a condition of probation. And people kind of laugh about that one. But the 2 things: number one, it helps you kind of remember in your mind that this is a 4,000-pound missile you're driving around, and it can do a lot of tissue damage if it hits something else or people. So we got to be very careful in the way we operate motor vehicles on public places. Plus, you're going to get a reduction in your insurance by doing this. So, so it's a win for a probationer. Here, please meet with the probation office, and you'll begin now. Thank you.
Thank you, Judge.
And now it gets dark. A super aggravated sexual assault charge of a child under 14, mandatory minimum 15 years, he took 45. There's no comeback from this level of crime, and the courtroom is dead silent for a reason.
All right, we now call 23 CR 1490, the state of Texas versus Joshua Booker, who is present with his attorney, Mr. Wilkerson, and the state's attorney. Does the defendant waive a formal reading of this indictment here? Can we proceed in summary?
He does, Your Honor.
All right. In summary, Mr. Booker, this indictment alleges in paragraph 1 that on or about December 1st, 2021, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here? Because the child was younger than 14 years of age, this becomes it's referred to as a super aggravated first-degree felony, which means the